All right, welcome back. Not yet. Welcome back. Hope everyone's doing okay. Any questions before we get started? Hopefully the camera works today, so I have that really awful angle of me like up my nose. I used to, back in the day before this camera, I would record it from my laptop, so everything was always up my nose, and it was kind of gross, but that was the only way I could do it. But now this one should work. I'm getting a new one maybe in a week or so this hopefully will survive, but still no live streaming, I'm sorry. But I'll upload it after class. Anything on your minds? Okay. Today we're moving on to a concept of property that often gets students very engaged, and it's called the bundle of sticks. And it involves what's called the right to exclude. And we do two cases which are not long. The reading today was, I think, mercifully short, but I'm sure you're all grateful. But I think it generates far more discussion than some of our longer cases we've had this semester. So let's take a poll, or actually two poll questions, one after the other. This one is your opinion. And the first question is, do you agree with the majority opinion in Jacque versus Steenberg Homes? This is the trailer case. Okay. Go ahead, another 20 seconds or so. Should be real easy. You should have formed an opinion by now, hopefully. Okay, another few seconds. All right, 3, 2, 1. Okay, good enough. All right, now the second question. Do you agree with the majority opinion in State versus Jacque? This was the New Jersey case with the farm workers. Okay. Okay, these are coming in quicker. Another 10 seconds or so. Okay. All right, 3, 2, 1. All right, stop it there. All right. I'm going to show you the results now. See how people viewed it. All right, so for question number, okay, do question number 1. So 87% of you, almost all of you really, agree with the majority opinion in the first case, Jacque. And for this one, it's closer. It's 76% and 23%. Now, you can imagine these cases are somewhat in tension, right? They're not lined up exactly. Let's try this. Did anyone agree with both majority opinions? Okay. Did anyone agree with the majority in the first case, but they did not agree with the majority in the second case? Okay. Did anyone agree with the second case, but didn't agree with the first case? Oh, that's the odd one. I don't mean you're odd, but that's a rare one, right? That is, you agree with the New Jersey case, but you disagree with the Wisconsin case.
I mean, I do agree with the majority in the first case, but I thought there's got to be some compromise, like something in between. Well, I guess of the two, I would choose the majority, but...
All right, anyone else agree with the New Jersey case, but not the Wisconsin case? Your hand's like this. What's this mean?
I agree with the first one to an extent. Sort of what he was going off of. I think there's a line between a delivery and health services that...
Anyone disagree with both of them? Cassidy, you disagree with both cases?
Yeah.
Tell me why.
Well, for the first one, it seemed like the reason that they were all right with the punitive damages being supported by the $1 nominal damages was based on a social interest and in order to incentivize people to not like be vigilantes, and I think that people should not want to be vigilantes.
Mm-hmm.
Because, you know, and that's they shouldn't. You really shouldn't need to like pay them not to want to do that,
Mm-hmm.
or to provide a monetary incentive. And with the second one, I think that the court didn't really need to. I think that the court was they were out of line.
Okay.
I don't really think it was the court's place.
Anyone else think both these were wrong? Because most people fall into this category of, yeah, they're both right. I agree with number one, I agree with number two.
Ask you a question.
Oh, yeah, please, Nancy, go ahead.
When you say agree with the opinion, you mean what they write in their opinion, not just the ruling?
Yes, ma'am.
Oh, then I have to change my answers.
Yeah. Yeah, I mean, that's one of the bad parts, right? When a court writes an opinion, you can't just say, I agree with the judgment, affirm or reverse, right? You have to tag along with all the reasoning. So what's your answer now that you said you modified it?
Now I disagree with the second one.
So you agree with the first one, but not the second one. Okay, you want to tell me why?
I don't, initially when reading it, I thought, well, isn't this like a a lesser lessee kind of thing where these people are tenants, they're providing work and he's providing housing, and so shouldn't they have rights to admit or exclude people? But then I started thinking from my social work background and remembering this quote that was in the Jacque case, where it says exclusive enjoyment of one's own property, in a way that does not invade the rights of others. And now we're talking about human rights issues.
Ooh.
And so.
Okay. Anyone else? We're going to go into depth, but just contrasting 1 and 2. All right, let me start and talk about these cases a little bit. I think this chapter in the book that sort of juxtaposes the Wisconsin case and the New Jersey case back to back is very helpful. What I find in the past that most students read, the first one's like, yeah, I agree with number one, that makes a lot of sense, right? And you read the Jersey case, like, wait a minute, I'm not so sure about number one anymore, right? And I think the case, the way they're lined up, is designed to do that. Okay, and by the way, there's not a right or wrong answer. These are simply your opinions, which don't particularly matter much to me, but I want you to at least see the contrast. Yeah, I don't care about your opinions. I know that sounds really mean, but it's of no concern what you think. I care if you understand the doctrine. It just really doesn't matter what your opinion is, and that's why I try not to give my opinion either. It really shouldn't matter either. But I do appreciate that if you reason why you think a certain way. Okay, let's do a little review from last class. Last class we did the Moore case from California, which involved whether the cells that are extracted from your body, right, who owns those cells. And the court used different ways of describing property, right? Property is not just a single block, right? We think of property as different sticks, right, in a bundle that kind of come together. And if you really need a visual, I have a picture of a bundle of sticks. You're welcome, right? They all come together and they form something that's useful, right? So maybe one stick in the bundle is the right to use it, right? Can you use the property? Maybe you can sell the property. Maybe you can throw it away and abandon it, or dispose of it, right? Maybe you can include. What do I mean include? The right to invite people onto your property. That's not a given, right? You might have a piece of property where you can't bring anyone on board. It's only you. What about exclude? Keep people off your property, right? We've touched on a lot of these concepts, right, throughout the semester, and I'll walk you through them. In the very first case, Johnson against McIntosh, remember the native people, they could not sell their land. They could live on it, but they couldn't sell it. Also, this may not have been obvious, but they did not have the right to include. That is, they were limited who could come onto their land. They were only allowed to have people of their own tribe onto their property. In fact, there were some cases that were decided later where aid workers were trying to enter the Indian reservations, and various governments denied entry of these think they were missionaries among others, but of these aid workers to try and get onto the reservation. The Indians also lacked the right to exclude. In other words, they couldn't keep people from coming onto their property. So they might have had maybe 1 or 2 sticks in the bundle, but they didn't have a lot of the important ones. Think of a far less significant case, right? Keeble, the duck case, right? Can you prevent your neighbor from firing a gun to scare away your ducks? And they had to go to court saying, yes, you could prevent your neighbor from trespassing, but also you could prevent him from discharging his firearm to scare away your ducks, right? Think of the INS versus AP case, the newspaper case, right? Could you exclude people from copying your newspapers? Well, you can't stop them from reading your newspapers. You can't stop them from buying your newspapers, but the court said that you can exclude them from copying your stories, right? That's a right to exclude. So over and over again, this concept of the right to exclude keeps coming up, right? And it's often said that the most important stick in the bundle, the most important element of any sort of property right, is the ability to exclude others. And by the way, exclude is a flip side of include, right? Because you can keep people off or bring in who you choose. So really they're one and the same. You choose who comes on and who comes off of your property. All right. Now the first case, we have 2, but the first case, the Jacque case, I think illustrates how seriously people take the right to exclude. Okay, let me make 2 brief notes. You've probably studied in torts the concept of punitive damages, right, or maybe in contracts. They're pretty rare, right? Generally, courts don't allow punitive damages, but they're permitted for one purpose, right? Punitive damages are not designed to compensate losses, right? That's what you call compensatory damage, like they compensate for your losses. Punitive damages, as the name suggests, are designed to punish, right? Punitive, punish, right? It's trying to punish really egregious conduct, really terrible conduct for a specific purpose, to send a signal, don't do this again. Because if you do this again, you're going to be facing a significant damage award. And the punitive damages aren't only designed to send a signal to the tortfeasor, right, the person who committed the tort. It's meant to signal to the world at large, right, society. If you engage in this conduct, it's really bad. And even if the damages are nominal, that, you know, drive across a snowy field, not a big deal, we're going to hit you with damages. Okay. A second point just to highlight is the role of jury instructions. Now, most law students never think about this. They're very important. When you get to a trial with a jury, one of the most important phases of the trial is what's called jury instructions. Juries find the law, right? I'm sorry, I screwed up. Juries find the facts, right? They decide, did you drive across this field, right? Did you ask for permission, right? These are factual questions, and that's the province of the jury. But the juries are not allowed, at least not supposed to, decide questions of law, right? The questions of law are decided by the court. Now, how does this work in practice? Before the jury goes to deliberate, the judge will read them a series of instructions. And he'll say, here's a definition of a trespass, right? Here's a definition of a battery. Whatever the legal standards, here are the elements. The same way, when you're a 1L, here are the elements of whatever offense you're talking about. You have to then consider the facts to apply to these elements. Very often the parties will fight over those definitions because sometimes the law isn't so clear. It's not like here are the elements of battery, which everyone knows and they can stand up and tell me with their eyes closed, right? So the parties fight over it. But one of the important issues in this case was whether a jury instruction was appropriate about punitive damages, right? Can you instruct the jury that punitives, or punies, if you will, whether punitives are permissible in this case? So that's a question that the Court of Appeals can consider, right? If the jury instruction was an error, then you wipe out the jury award of punitive damages altogether, right? You decide, can the court instruct on punitives in this case? And that's a question of law. So you're not really taking away the jury's decision. You're simply saying, could they have been even given the chance to consider this in the first place? I'll make one other point. If you ever do appellate work, right, one of the most common issues for an appellate court to consider is whether the instructions were correct. Because if the lower court gave incorrect instructions, you wipe out the jury verdict, right? You knock it out. Because if the court gave the jury the wrong law, then it doesn't matter if the legal facts are, right? The courts of appeals generally don't second guess the jury on facts unless it's really, really screwy, right? But if there was a legal standard that was messed up, that they gave them the wrong legal standard, you can wipe out a jury verdict on appeal. So just keep that in mind. Whether you do trial work or appellate work, the instructions are so important. Okay. Any questions so far? Okay, where am I up to? Who's next? Is that Giancarlo? All right. Do you want to give me the facts, please, in the first case, Jacque versus Steenberg Homes, Wisconsin?
So there was the Steenberg home had to deliver a mobile home.
Right. And just if you don't know what this is, it's basically these modular homes. Like they put them on trailers on wheels, and you can move them around. Right. So it's an entire basically home that you can move around anywhere. All right. Go ahead.
So they were trying to deliver that mobile home, but the best way to deliver that mobile home was through the land of.
Why couldn't they just use public roads to deliver the home at this time?
There was snow.
Snow, and then maybe if you're in Texas, you've never seen snow. I think you've all at least seen it, but you've probably never seen 7 feet of snow, right? At the time, there was a huge snowstorm, right? And there was a road that you could have taken, which had lots of snow on it, and a very sharp curve. Now, just so you understand, it's very hard to drive on snow in general. Try dragging a massive trailer home, right, mobile home, on a sharp curve. It could jackknife. The entire thing can flip over, and that's just a disaster. Okay? So Louisa, what happens? They realize that it will be probably really dangerous to use this private road with this snowbanks. What do they decide to do? Oh, Adam. She's like, I'm sorry.
So,
Adam, go ahead. Yeah, please.
They found that the easiest way to go about delivering it would be to go through Jacque's property.
I think it's Jacque.
Jacque. Or Jacque.
It's okay.
Just Jacque. I don't know.
Okay.
Jacque.
Okay.
But either way, they went and they asked him, obviously.
Okay, so they asked the owner of the property, right? They said, we want to cross your land, right?
And he was not about it.
Did they offer to pay?
Yes, they did.
They offered to pay. Now, what did Mr. Jacque say in response when they came along?
Well, they basically determined, or that he had said that he just blatantly refused.
Yeah. Right. So first they say, can we please cross your land? We'll pay you for it, right? We'll pay you for the inconvenience. And just so you know, there could be a cost, right? If you're dragging this ginormous trailer, it could leave tread marks, right? Tire marks on the grass, right? Which, that's non-trivial. I am not sure, actually, because of the snow, there may have been actually no impact. I don't know how much snow is in the field, but in theory, at least, we'll just presume that the tractor trailer, the tires could have left track marks on the ground, right? Is your hand up? Okay, go ahead next anyway. Okay, so first they said, we'll pay you. And he's like, no, follow the road. That's what the road is for. And then Jacque protested more. Apparently, he had problems with his neighbors, right? Usually in these cases, you have people who are, they don't get along with others. Let's just leave it like that, right? They have social issues with their neighbors. Okay, at that point, the Steenberg manager said, I don't give a blank what he said. Fill in the blank. Just get the home in there anyway. Because think about it. This is their business, right? And if they don't deliver the trailer, they could be in breach of some other contract, right? There's other consequences for failing to deliver on time. Okay, so Naveen, what does Steenberg do after Mr. Jacque says can't do it?
They used a bobcat to cut a path into
Yeah.
Jacque's property and move the mobile home.
Yeah, and they drove across the field. And apparently they were giggling and laughing, which seems kind of juvenile, but whatever, right? It seems like, you're a little kid, you're giggling and laughing. Hey, look at us, right? It's like the Astros banging on the drum. Oh, I'm sorry. Oh, too soon? Because you know what you're doing is wrong, but you're doing it anyway. Oh, sorry. Yeah, sorry, too soon? Too soon? But did you see the Astros that when they were asked about it, yep, it happened. We're not going to talk about it. You can see they know what they did was wrong, and they just want to admit it. Yeah. It's amazing. It's actually a good instance when you're a fan of a team, you can see no wrong. And this is actually manifested in betting, right? If you look at how people bet on sports, people are willing to bet for their home team even if the odds are against them, right? They just make irrational decisions because of their loyalties to a team. And whether it's sports or politics, it's much the same, but people who are committed to their cause. Even a couple years ago with the inflated footballs, remember that with the Patriots, with the inflated footballs? People in bus like, it can't be, and then, or the Spygate recording the, anyway, so I'll leave it there. But generally, people know when they're doing something wrong, and they just sort of like, whatever, right? And so here they were driving across the guy's property, and they knew that they weren't supposed to. Now, why do you think, Chance, they decided to just drive across his lot or his field? What calculation do you think they made at that point?
My guess is they said, okay, well, we're probably going to get a citation, which they did at $30. Worst case scenario, we pay the citation. He's angry. Who cares? Everybody else in the area is probably pissed off at him anyway.
Yeah.
We get done.
Yeah. I think he's exactly right. I think they made a calculation. It's going to be cheaper to pay damages, right? They offered to pay him probably more than $30. He wouldn't take it. And they said, okay, sucks for him. We're just going to trespass. And I mean, they knowingly violated the law. They knew what they were doing. This is not like, this wasn't like a borderline call where they weren't sure. They knew this was against the law. They said, this is cheaper to pay the damages than to have to go along and drive on this sharp embankment and maybe jackknife the trailer. All right, so Jacque calls the sheriff. This is a simple trespass case, right? They were on the land for probably a few minutes. They didn't dwell. They didn't probably do any lingering damage. And they got a $30 citation. Now, Jacque was pissed. And what did he do, Anthony?
He filed an action in court for trespass.
Exactly. Right. He filed an action in court for intentional trespass. Now, Anthony, what were the damages that the jury awarded?
They awarded him a $1 nominal damage.
Right.
And $100,000 punitive.
Yeah. So let me just let me pause you right there. The fact that there's only $1 nominal damages suggests, to me at least, there was no track marks, right? It didn't actually leave any lingering damage to the property. Because if it actually damaged the grass, I think you'd have a damage award of something greater than $1. Whatever it is, just something greater than $1. So I'm guessing they cleared most of the snow, but they drove on at least some thick snow and didn't leave any damages, right? It would have been actually worse perhaps in the summer, but I guess in the summer they could have went the road, so whatever. But the jury was given the option of awarding punitive damages. Jay's your hand up? Okay. But the jury was giving the option, but then the court set aside the jury award of $100,000. Right? Courts have the discretion to set aside jury verdicts. Remember the J&OV, right? The judgment notwithstanding the verdict? That sound familiar? Bring back awful memories, right? In some cases where a jury really screws things up, completely botches the case, judges have the authority to take back the verdict. In this case, the trial court said, what are you, insane? $100,000 for this? I'm wiping out the verdict. Jacque appeals. Natalie, what does the Court of Appeals do at this point?
They affirm it, and they reluctantly conclude that they cannot reinstate the punitive damages because an award of nominal damages will not sustain a punitive damages award.
Okay, you said a word there. You said reluctantly.
What? I'm sorry.
You said reluctantly.
Yes.
That's a very good word. Why did you use that word to describe the opinion? I think that's actually a very... but what do you think that means, reluctantly?
Reluctantly, like they didn't really want to, but they did it with a little bit of hesitation.
So you think they if you ask them outside court, it's like, yeah, that's an appropriate award? Probably not?
Reluctant.
Well, but did they award the punitive damages or not?
No.
So they reluctantly took out the punitive damages. What does that suggest? What do they actually want to do?
They wanted
Give them.
to give it.
Yeah. So I think the way I read that, and maybe you disagree, is that they probably would have felt comfortable with the punitive damages award, but they reluctantly set it aside. Because I think they maybe had some sympathy for Mr. Jacque, and they didn't like the fact that the Steenbergs deliberately violated the law, right? Usually if you violate the law negligently, it's like, okay, whatever, he didn't know. But here, they knew exactly what they're doing. They drove across the field, giggling and laughing like a bunch of old kids, right? All right? So the Court of Appeals said we cannot reinstate the punitive damages, and especially think of the disparity, right? Usually the punitive damages are somewhat related to the actual damages, right? So maybe, let's just say you have an actual damage of $1 million, and say the punitive damages are $2 million. All right, I mean, that's in the ballpark, right? It's relative. But here you have a $1 damage award, which basically means no actual damages. And then you got $100,000 for punitive. It's out of whack. In fact, there are some cases, which I don't think you mentioned in SIFPRO, but they exist, where courts say if the difference between the damage award and the punitive damage award is too great, it actually violates the due process clause. It's unconstitutional. Don't worry about those cases. You won't even say them in con law, but there are cases that limit the size of punitive awards that have to be somewhat in proportion to the actual damage award. Right? That's not in this case, but there are cases about that otherwise. Everyone with me? All right. Lex, you said when we get appealed to the Supreme Court of the state, and what does the Supreme Court of the state hold?
They affirm the Court of Appeals.
Okay.
Holding that it's the right to exclude another from one's land is like one of the most important sticks out of the bundle of sticks.
And what about the punitive damage award? What does the Supreme Court do?
They reinstate it.
They did. So the state Supreme Court, the highest court in the state, decides to reinstate the jury verdict. The jury verdict of punitive damages. And the state Supreme Court says that they may be awarded in the discretion of the jury. So they don't say that punitive damages are required. They say is that the jury, in its discretion, may award punitive damages. Right? So Madison, let me ask you a question, please. Who do you think sat on the jury in this case, in this trial?
Probably other landowners
Where?
in the same county or in their neighborhood.
Exactly. In fact, the Constitution requires members of, at least in criminal, but generally jury members have to be in the same, what's called the vicinage, or the area where the tort occurred. So how do you think the sympathies were, Madison, the people on this jury? Were they with the mobile home company or the farmer?
Probably the farmer, because
Yeah.
I would imagine they also would not want a mobile home driven across their property.
I think that's right. And I think when they gave the $100,000 punitive award, that came from their own sense of, wow, I don't want this happening to me. If we give this strong award, we'll send a signal. They won't trespass on his land. They won't trespass on your land. They won't trespass on my land. They won't trespass anywhere. So I think what's going on here is that the jury itself was worried about what precedent would be set by letting this happen. Because they're saying, well, if it's just $30 or $1 damage, you'll just trespass on my property. What the Supreme Court says here is that the jury decides in their discretion to give a punitive damage award of $100,000, and that's appropriate. It's not for us, right? It's not for us to second guess. Okay? And they cite a case called Kaiser Aetna versus the United States. You'll see this case cited a lot. And Kaiser Aetna is a Supreme Court decision which held that the right to exclude others from land is one of the most essential sticks in the bundle of rights that are commonly characterized as property. See, I didn't make up this bundle of sticks. I think the Supreme Court recognizes it, right? It's this bundle. Not often agrees with the bundle of sticks. It's not a debate I care much to have, but it's a pretty predominant view. Then the court says in Wisconsin, the right to exclusive enjoyment of property exists so long as you don't invade the rights of others. I think someone mentioned that. Earlier, right? But the court says that this right is empty, it's hollow, if you can't have a legal system protect it. Jacque had the right to tell Steenberg, no, you cannot cross. That was his right. And this right is meaningless if it's not protected by the state. Right? It's blocked, I can't say it. Yeah, Sarah. Thank you, Sarah. What does the court think would happen if only nominal damages were available in this case? If only nominal damages are available, what would that do? What would the consequence be of that? Yeah, so thinking about deterrence, right? Sarah, where have we talked about deterrence before? What kind of cases have we thought about that issue? It comes up in a lot of our discussion so far.
Yeah, we talked about it in all of our cases.
That's a good answer. Give me one of them.
Um,
Which one?
the Moore case.
Okay, which one? Tell us about the Moore case. Why was deterrence there relevant in the Moore case?
So that was the one with the magic cells
That's right.
from Moore. And so they would want to deter like unnecessary surgeries, or doctors trying to get things like
What would happen if the court granted a property right to Mr. Moore in the cells? What would that do to research?
that could make people want to sell their
That's true. That's true. I see a D. Yeah, Doug. What would have happened if the court ruled for Mr. Moore in that case? What would that have done to the state of research for science?
It would have made it really difficult to get research done because they signed property rights to
Yeah.
every single person who sells.
Yeah, so that's a case where this idea of deterrence is important, right? They want to promote research and deter the sort of copying stuff where you don't have enough money to investigate. But we see this in even far simpler cases than the medicine case, right? Mandy, what would have happened if they adopted a rule in the whale case, right? And the rule is this: whoever finds a whale on the beach wins. They own the whale. What would have happened if the court adopted that rule in Gen?
people have been fighting over them.
Okay, what would have happened to the whale trade, whale hunters?
They wouldn't have wanted to hunt anymore. It's too much work.
That's right. They would not have bothered hunting because someone can just steal their whale. Courts are always thinking that if we do this, what's going to happen, right? What are the consequences of our ruling beyond this case? And I think what the Wisconsin court is saying here is that if we allow this trespass to happen without any sort of punitive award, everyone's going to trespass, right? It's going to be a common thing that people just start driving over fields instead of going through farms. Now, is it accurate? I have no idea, right? Who knows if this is common, this will ever happen again? But the court is worried, right, that the nominal damages are not enough. The nominal damages are not enough. They even reference intentional trespass in unrelated actions, right? They mention there might be other cases, and they want to say we don't want to threaten the ownership of land. Society has an interest in punishing, deterring intentional trespassers beyond protecting the interests of individual landowners, right? This judgment is not only about the Jacques, it's about the entire state and protecting their property writ large. Private landowners should be confident the trespassers will be punished. Okay? Is that a hand?
Yeah, I was just kind of curious. In a situation like this where, okay, obviously this is some form of economic commerce occurring, they're just trying to transport the good that they have. Would there ever be a situation where, like, some form of eminent domain for a brief stint, because potentially would be highest and best use, like at that moment, let's say for the hour they had to
Well, eminent domain is from the government. Are you asking for the government to occupy land?
The government uses it privately all the time, so I was just like curious.
There are several components for your question. You'll do eminent domain and property too. Eminent domain is the power of the state to seize land. So you're asking about if the government temporarily seizes your land. And this actually happens quite a bit, perhaps in a case you're familiar with, flooding, right? In Hurricane Harvey, the U.S. government, the federal government, flooded some people's homes temporarily to prevent the dam from rupturing. And there's litigation going on right now about whether that temporary taking results in a violation of property rights that requires compensation. So this does come up. A far easier example is what happens if there's some sort of police investigation and you live across the street from this investigation, and they want to use your house for a stakeout, right? They want to just sit there and watch. And there are cases about that as well. All right. Moises, the court also discusses self-help. Remind us, what is self-help?
So the way they described it was they could use landowners, people who done
Yeah.
Punch the tires out the road.
Yeah, in other words, if the landowners thought that, they're only going to be $30 nominal damages, whatever, right? What might they do instead to try and deter this conduct?
Defend their land.
Yeah. And is the court happy about that? No. Right? Yeah, you probably learn about self-help probably in torts, right? This is the idea where you take the law into your own hands, so to speak. And if there's a trespasser, rather than calling the cops, you shoot them. Or in this case, rather than calling the cops, you puncture their tires or you shoot them. You shoot something. And the courts worry that if there's not sufficient protection of property rights, people will resort to self-help, and that's bad. Courts don't like self-help. They like when you use the courts. And here, to his credit, right? Did Jacque shoot them? No. He probably could have, but he didn't, right? In fact, arguably he could have shot them. They were on his property. But he didn't. He went to the courts. I think the courts say, if you go to a judge, we'll reward you with this sort of damage award. Oh, yes, sir, Cassidy.
Why couldn't they just make it so that the citation costs more money than $30?
Okay, so a few points. Which branch of government establishes the schedule of fines for citations?
It would be legislative.
Or maybe the executive, not sure here, but generally the fines that a sheriff can issue, there's probably some discretion, but it's been like no more than this and no less than this, right? There's probably like a range of fines. Like if you ever get a speeding ticket, right? It's like if you go this many miles over, it's this amount. If you go this many miles over, it's that amount, right? You know these tickets. If your parking meter is expired for 1 hour, it's this, and 2 hours, it's that. So usually it's the government or the legislature that sets fines. I don't know that the court could modify the fines that are set by virtue of this regime.
Yeah, I mean, I would think they would have to be, it would have had to have happened outside of the confines of this case,
Yeah, I mean, look, maybe the state could modify the statute and say if there's an intentional trespass in which you've asked for permission and you're told no, the damage is $1,000 an hour or whatever it happens to be.
It just seems like if that's what, is really important to everyone.
And so who would do that? Would it be the people's representatives or a single jury of 12?
Yeah, the people, it would be the constituency would vote and the people's representative would help out with that.
And do you think if you were a member of the Wisconsin legislature, you would pick $100,000 as the number? No. Right, so again, here the jury may have just been way out of, you didn't like either of these cases, right? But the $100,000 award, I mean, who here thinks this is absurd, right? $100,000 for, I mean, this is what, almost 20 something years ago. This was even more money back in the 90s. I mean, this could just be an absurd thing for a temporary trespass. Yeah. Okay. I'll call on other people too, but just finish it up, yeah.
Just in relation to the $1
Yeah.
nominal damages, there was no.
Yeah, that's a significant point. I think Marissa was your hand up a minute ago? That's right. Yeah, Jill.
I don't disagree that the $100,000 in punitive damages was excessive, but do you think that the lower court maybe felt like these trespassers had such a blatant disregard for someone else's property, they should pay as much as the jury thought we should make them pay for this, even though it was probably excessive.
Yeah, I think the blatant aspect is important, right? Because usually when you're trespassing, you may not know what the boundary is, maybe you have a mistake of fact. Here, they knew exactly what they're doing and they basically said, screw it, right? We made a decision. It's going to be cheaper to pay a citation for trespass than to pay the cost of moving in the snow. So I think generally in law, when you do something deliberately bad, you're in a much worse position when there's a dispute of fact. Because most of the cases, think about it, right? You have the two hunters. They don't disagree. They disagree on the correct standard, right? One thinks it's rule of capture, one thinks it's labor, right? But here, the law is clear, right? The law of trespass has been around for a very long time. There's not any doubt what they're doing and say, you know what, we're going to do it anyway. Okay? Yeah, Nancy in the front.
So why would it, couldn't the trial judge have just, I don't know what verb he issued or granted a remediature instead of.
Remediature, remind me what that is. I think I know what you're talking about, just to be sure.
Well, if I'm correct, it's reducing the amount of.
Oh, to reduce the judgment, yes.
Can you do that only for compensatory damages, or can you also do that?
You could. The judge could have also said, I'm reducing the punitives to $5,000. And I think the trial judge would have had the discretion to reduce the punitives to $5,000, for example.
But the subsequent courts
Could have
allow-
reinstated it.
Or they can remand it for remand?
I think, to be frank, I think if an appellate court found that the amount given was excessive, you'd have to remand to the trial court to decide what the appropriate amount is. I don't know. I don't know Wisconsin whether an appellate court could change a jury award. Usually appellate courts give a thumbs up or a thumbs down. They can't tweak the judgment like that.
Okay.
I saw a hand some over here. Jay?
That was where the reluctant word came in for me, specifically because of that. I figured that they must have been restricted from reducing it after it was at the appellate level.
I think that's probably right. Usually appellate courts can't modify verdicts in that fashion. The appellate courts can usually give a thumbs up or thumbs down. They can affirm or reverse, or maybe affirm in part, reverse in part. They can't make those sorts of findings because that's maybe Wisconsin allows some. I'm going to just hedge a little bit, but I don't think they can. So I'm pretty sure, but I'm not positive. Yes, name tag. Jenny, there's so many of you that the name tags get blocked, but it's a good thing. I'm getting your names slowly, but yeah, Jenny.
How many fines or slaps on the wrist or how much time has to go by before the landowner is worried about it becoming a prescriptive right?
Yeah, so her question was prescriptive easements, right? We didn't do that in this class, did we?
Not yet.
No, we will. Okay, so the idea is in property, if I walk across your land every day for a decade, every day I walk across your land, and you know I'm doing this and you don't stop me, I actually gain a right to cross it, what's called a prescriptive easement, right? You'll do this next semester in property too. A one-time trespass doesn't lead to that, but if you cross someone's land every day, you would. But it's called a prescriptive easement. Chance?
How far does that extend? Because I have like a lot near my house that I've walked my dog at for the past year. I don't think I have a prescriptive right to that, but I mean, do I have a case for that?
The short answer is wait till property 2. But generally, if you're doing it with the consent of the owner, you're not getting prescription.
What if it's no consent of the owner?
If he doesn't know about it?
Yeah. I mean,
Well, if he doesn't know about it, then it's not either. He has to basically, for prescription to work, you have to be aware of it, not stop it.
well, he's probably where the entire
Ask me after class. Yeah. Yeah.
So let's say that I own a piece of property that's like to get to from a public road, I have to cross someone's property. I bought that property from someone who they originally let use the road. Do I get the same right to use
Oh, you're asking all these property 2 questions. Let me. This is an exceedingly complicated area of the law, so I'm just going to table till next semester. But the short answer is, if you're walking across someone's land, they know you're doing it. They don't want you to do it, but they let you do it anyway. Then if you do it for a decade, you get to keep it. But good luck trespassing for a decade with the guy knowing it and not getting stopped. That's going to be very rare. Very rare. All right. Other questions on Jacque? Yes, Nancy?
I'm confused about why the trial court and the Court of Appeals thought that.
That's not explained, is it? Yeah.
Yes. Is it just that they thought it was outrageous 1 to 100K, or is it that there's really law?
Usually in tort cases like this, you don't get punitive damages, right? Usually with like an intentional trespass case, punitive damages are not awarded. This is just very rare, right? Usually if there's like, some sort of really egregious murder or some sort of really egregious behavior, but I think they probably thought it just wasn't appropriate in this case. But you're right, it's not really explained why they set it aside. That's also, trial courts don't always explain their reasoning, right? Usually trial courts don't write opinions. They just issue a judgment saying, I'm setting aside the jury award. If you don't like it, appeal. All right. Is that a hand? Questions in the first case? On Jacque. Jacque. Yeah, Tony.
Trouble seeing why it's excessive. I think it's a fair amount.
Well, let me ask you, has anyone ever served in a jury before? One of the hardest things that I can imagine on being a jury is coming up with a dollar amount, right? How do you come up with a dollar amount? And let me make this point bluntly. Remember what I'm about to say very clearly. If you're ever in a jury trial and you're the lawyer and you say, I think the punitive damages should be X, congratulations, you have a mistrial. You can't do that. The lawyer cannot tell the jury even a hint of what the punitive damages should be. You can give a guidance on the compensatories. You say, here are the medical bills, right? Here's the here's how much money we spend for travel, right? You can give receipts to establish what compensatory damages are. But if you go to a jury and you say, here's what the damages, the pain and suffering that we suffered is like worth $1 million, congratulations, you just got a mistrial. So don't do that. So now let me go back to Tony. You're in a jury. You just heard the evidence in this case. Where do you come up with a number? How do you come up with a number for punitive damages? Where does that number come from? Just you pull it out of the air?
I mean, I'm assuming it's other farmers in the area and stuff, and they're thinking about their stuff.
Yeah, again, how do you come up with a number?
So if I'm on the jury, I'm just going to throw out a really high number and then go
$10 million, like $1 billion. What number are you putting out?
I don't want these people going across my land. And I'm
So, but I mean, but how do you come up with a number, right? Someone asked earlier, is there a relationship between the number of punitive and number of compensatory? It's 100,000 times greater. Where do you come up with that number? 100K. Cassidy.
The number might have been like however much it would have cost them to get the rollers that they would have needed.
To get the what?
The rollers, they would have had to buy rollers to use as part of the road that they were trying to avoid.
So basically, you make them pay what they would have paid otherwise.
A little bit more than that.
Would that? Do you think that's 100 grand?
I don't know.
Yeah, raise your hand. But yeah, I think not even close. Clayton, with your hand up also?
Yeah, I was going to say that, like, if you could be the potential damage to the field that they would possibly
but that's nominal.
But that was
But that's nominal. If there was actually, let's say, grass that was destroyed, you can put a dollar amount. To have sod, to have a gardener come, like you can quantify this. This was purely a matter of deterrence, right? So this is like, pardon my French, but this is like FU money, right? It's basically saying, don't you ever do this again, right? It's like saying, FU, don't do this again, 100 grand. That's what this is. This is not to the grass or anything else. That's my hand there. Yeah. Yeah.
Where did this case take place? I know it was in Wisconsin, but was it in like a rural?
I'm guessing generally it was you're not driving across a field in a city, and Wisconsin's a pretty rural state in general.
Do you think that would have something to do with the damages that were assessed?
Yeah, I think the veneer, the jury pool was mostly going to be farmers. Absolutely. Yes, Sarah.
I feel like at the end of the day, the jury's just going to like decide their punitive damages based on how sorry they're people or how convincing the argument.
Yeah, but where does the number come from? One guy says, yeah, 100 grand. Yeah, that sounds good. I agree.
I feel like it's just how convinced they are.
So I've never gone to a jury to a trial because I get excused very quickly because they don't want a law professor. You do not want a law professor in a jury. It's a bad idea. Because I'll tell everyone what the law is, and then it's a bad idea. But one second. But when I was a law clerk, I served in a couple of bench trials, right? In a bench trial, there's no jury, right? The parties actually ask the judge to resolve it. And I'm going to tell you, in one of my cases, I had to come up with a number for pain and suffering. I struggled so much because I had no idea how to come up with a number. I had no idea what to do, right? How do you put a number in pain and suffering? And the parties can't give you a proposal. That's not allowed. So I'm sitting there in my office thinking about this case saying, how do I quantify pain and suffering? It's not an easy question. So I don't mean to give Tony a hard time. I think I struggle with it mightily. But just think for yourself, right? If something bad happens to you or a friend, how do you put a dollar amount on that? And juries do it all the time. And the numbers they come up with, I guess are reasonable, but I don't know. Yeah, is that Dylan? And then Chance.
I just think it might have been a little easier for these juries to put up a good number on it because they were farmers and maybe they just considered how much could I put on this to deter future trespassers.
Just 100,000 such a strong number that's going to create a signal.
Mm-hmm.
Maybe. Joe's hand?
No, but maybe they're just
Okay.
not like the defendant.
The mobile home company. Yeah. I think that's probably true. They thought these guys are jerks. And Chance?
Are you allowed to use up a stare decisis as a juror? Like you go say, hey judge, we have no clue we're in the same position you were. Do you have any other cases where Wisconsin that people were
That's a good question. I don't know. I don't know if the lawyers can introduce verdicts in other cases because that might be too suggestive. Right? If you say, here are the punitive damage awards issued in XYZ case, that might be too suggestive. I don't know if they'd be allowed to do that. It really, I mean this quite seriously, you should not be giving the jury suggestions on how to reach punitive damage awards. that's something you can't do because it can lead to a mistrial.
What could you say? This is the highest punitive damage ever given. Here's the lowest, and say.
I don't know if you can even do that. I mean, in some states, by statute, punitive damages are capped. Right, so that might be permissible. You can say here's the state limit on punitive damages, so then they know what their range is. But I don't know if Wisconsin has such a limit. It's a weird thing because the purpose is not to set any sort of standard for all cases. It's in this specific case, how do we punish these SOBs, right? How do we punish these really bad actors? And that's not something that can be anticipated in advance. And maybe the actors here are so much worse than in the other case you mentioned. How do you compare A to B? All right, other cases on Jacque. Seriously, a short case, but almost an hour of discussion. It always happens this way. All right, let's move on to the second case, please. The second case is called State versus Jacque. Oops, wrong one. Okay. Now, I hope you can see this on the screen. This was an article in the New York Times from 1970 or 71 about the workers, the aid workers who were arrested. Now, where am I? Who am I up to? Okay, that's yeah, John. Thank you. Now, John, generally, when people get arrested, are reporters from the New York Times present to take their picture?
Not usually.
Not usually. So, how do you think this picture came about, where these people were getting booked by the cop, as a reporter from the New York Times was there and a photographer was there as well?
I'm assuming somebody got a tip.
Oh, more than a tip. What do you think the farm worker was trying to do here?
Send a message.
Close. Alexis, what do you think the farm workers were trying to do here, or the aid worker was trying to do? Yeah, what's that word?
They planned it.
They planned it. And what were they trying to set up? There's a word for a phrase.
To show that they're living situation.
What do you call that? Anyone know? It's two words.
Influence operation.
That's good. That's what I'm thinking of, but it's close. Test. A test case. Oh, you know that phrase? Ah, okay. Let me tell you this phrase. Okay, you should have learned it, but if you didn't, I will tell it to you. A test case, right? A test case is when you deliberately try to break the law to challenge the law's validity in court, right? A test case is where you deliberately try to get arrested or break a law so you can challenge that in court, right? If I don't like some law, how do I get rid of it? Well, maybe I ask the legislature to repeal it. Maybe I ask them to create a new bill, right? There's a process. That takes a lot of time. Who wants to change the law when you go to court? So instead, the plaintiffs here, I'm sorry, actually the defendants, I should say, the farm workers, the aid workers, said, you know what, screw this. We are sick and tired of these farm workers getting abused, and we're sick and tired of having this trespass statute being used against us, so we're going to get arrested. And we're going to challenge the application of this trespass statute to the farm aid workers. And by the way, we'll have a reporter from the New York Times present to document the entire thing to make sure nothing bad happens. So this was a setup, right? And I don't want to say it's bad, right? This is fairly common, right? You'll learn about this in common law, right? When those famous cases or infamous cases, Plessy versus Ferguson, was involving a segregated train car. How did the case begin? Homer Plessy went into the white car. He knew he would get arrested. That's why he did it, to set up the case, right? Griswold v. Connecticut was a famous case about a right to contraception. How the case began? You had doctors at Planned Parenthood basically prescribing birth control, knowing they get arrested. And they did it to challenge the Connecticut contraception law. So you might call it civil disobedience, use whatever label you want to use. What did you say, Chris? What word did you use?
Influence operation.
I've not heard that before. Is that you make?
I've heard it to describe a situation where something like this occurred, but they pre-planned it to have the media there.
Yeah. Yeah, okay, so influence operation. I don't think I've heard that phrase, but same idea, right? You deliberately violate the law as a means to set up a court case. And the court case is designed to break the law. Okay. Everyone with me? Everyone okay with that? All right. So now let's try and do the facts, right? Jace, give me the facts of this case, please. Okay, so before we get to the aid workers, can you just describe for me, please, the situation on the farm where the workers were living? Just describe that, please.
I don't think it was very good. I mean, they had their own little place there.
Well, who were these people living on the farm?
They were migrant workers.
Okay. Were they citizens?
I think they were. I don't remember it saying.
No, Elias?
No, they weren't.
Okay. And what were they doing on this land? Just so we understand their role.
They were working in agriculture.
Okay. And generally, is agriculture a year-round job?
No, it's seasonal.
Seasonal, right? There's a planting season and there's a harvesting season. So these weren't full-time workers. They would basically come, do their job at some point, and they would leave, right? So Elias, describe what were the conditions like for these people on the on the farm?
Well, I guess they were kind of isolated.
Isolated? How so?
They were kind of at the mercy of the landowner, and they couldn't, their right, so to speak.
Could they come and go? Were they allowed to leave the property?
No.
Well, they probably could have leave, but they weren't fired and not paid, right?
Yeah.
Were they allowed to invite people onto the land? Were they allowed to have guests?
Probably not.
No. Okay. Ryan, were they allowed to have people come onto the land to help them with medical or legal issues?
No.
Okay, they were not. And then what prevented aid workers from coming onto the property to help them?
The owner of the property refusing to allow them.
And what law was the owner relying on?
The one that we examined in the prior case.
And what's that law called?
The right to exclude.
Trespass, right?
Trespass.
Yeah, thank you. Trespass, right? So basically, right, these workers in theory could have left, right? I don't think they were actually prevented from leaving. But they left, they probably would have lost their jobs, they wouldn't have gotten paid, and they needed the money. So practically speaking, the only way for them to get medical care was on the lot. The owner of this lot used the trespass statute to prevent aid workers from coming on board, right? And he said to them, if you come on board without permission, you are trespassing. You are no different than the mobile home company that walks over, that drives over the field. All right, so let me give you some background. This is in the article. I know it's hard to read, so let me read it for you. Okay, so the owner of the farm was named Mr. Tedesco. And so Tedesco said to a reporter, I'll smash you for this. I'm going to get you for this. This is my property. You can't come in here looking around. Another farmer told the reporter, even President Nixon, who was president at the time, would not be allowed in here. Another farmer said that they would resort to violence to repel those trying to help the workers. Okay? In short, they were using the trespass laws to keep the migrant workers isolated. Now, I said they were allowed to leave the farm. I think I'm correct about that. But the farms are pretty big. And maybe you had one location here, and one location here, and one location there. Genevieve, were the farmers allowed to move around the farm? Well, let me tell you this way. Let's just say, remember in torts you're like an invitee. Remember that concept, right? So if I say you're a plumber, right? And I say, you know what, Genevieve, you can come to my house and you can fix the shower in the bathroom, right? Does that mean you can go to my living room and sit on the couch? No. Does that mean you can go to the kitchen and have a snack? No. You're invited for a specific purpose. So let's just say, you go to a migrant worker and say, you know what, you're invited to go to the tomato farm. Can they go to the apple farm? No. Right. So you think, could they move around between parts of the land? No. That's how they were kept isolated, right? They were basically invited, so to speak, to work on a specific portion of the land, and they could not go elsewhere. In theory, if they were invited for the tomato farm and they went to the apple farm, they could be arrested for trespassing. So basically they were locked, right? They weren't actually bound to the land, but as a practical matter, they couldn't even move around and talk to people on the other side and communicate. So information was hard to share. The camp was in very, very bad conditions. There was only one toilet in the entire lot. There were 7 people to a room. There were no mattresses or sheets or covers. And then we have these 2 incidents, right? Jacque was one of the workers. One of the aid workers. And he investigated. He found that a 19-year-old had cut his hand while working. And he could not receive wages. And he was basically stuck there. And the Tejeras heard that there was another person who had his face slashed. And he had to get sutures, right, stitches removed from his face. The workers made about $9 a week. And sometimes a family of 12 would sleep in one small room. And they didn't really want running water. So bad conditions all around. All right. So Grayson, tell me a little bit more. Who were these workers? What exactly were they? What was their position? What were they trying to accomplish? Yeah, the aid workers. I'm sorry. Yeah.
Well, one was there for medical aid, and the other was there to give legal advice.
Right. And these people were funded by the federal government. It's not really important. I don't know why the court makes a big deal, but they were given federal funding. Okay. All right. So they come onto the farm. Tedesco confronts them, and he says, "Look, if you want to talk to these people, you have to do it in my office, right? Yeah, I have to be able to observe what's going on." They decline because they want to see them without supervision. At that point, Tedesco called the cops, called the state troopers. Samantha, what happens next?
The state trooper refused to remove them.
Yeah, unless
you, as a plaintiff, Tedesco had made a written.
Okay, why do you think, Samantha, the state trooper didn't want to get involved here?
Because they were set up. I guess they had.
Yeah, and maybe be a little more charitable. Maybe he thought this was a really bad idea to arrest these aid workers. But Tedesco wrote out a complaint, didn't he? And what happens next?
And then they charged him for trespassing.
Yeah, that's what this picture is. That's the state trooper, and he's basically writing them up. And look, these guys knew they were getting arrested, right? That's why they went to this farm. That was, whether you say they were set up, but their goal was to get arrested for the day. Then the case gets kind of funny, right? Generally, after a police officer writes a citation, Garrett, what happens next? What happens next? After a cop arrests someone for trespass, what's the next step? Is there anyone else involved in that process?
I guess I don't understand what you're
A police officer arrests you for trespass. Is that it? Is that the end of the process?
Then you go to trial.
Who controls the trial? Is that the cop who controls the trial?
Judge controls the trial.
Who's bringing the charges?
The state.
What do you call that person?
The cop.
No. What do you call the person who brings charges against someone in a criminal trial?
The prosecutor.
Yes, a prosecutor, right? It's not enough for the cop to arrest someone. The prosecutor has to bring the charges. Did the prosecutor here, Garrett, want to bring these charges?
No.
No. Why not?
Because it's a bad look all around.
Bad luck. Okay, thank you. In this case, no one sought to sustain the convictions. No one wanted to defend the conviction, right? The landowner, Tedesco, didn't respond to the appeal. He really had no role. The county prosecutor, who actually got the conviction, did not want to defend it. He's like, we don't want to deal with this. So, oh God, I can't read that. That's too hard to read. What does that say? Megan, can you do normal black letters? I can't see the blue. It's hard to read for later. Yeah. Oh, that's great. Thank you. Wow, that's magical. Megan, so let me ask you a question. In an appeal, if the government doesn't want to sustain the conviction, that is, the government doesn't want to defend the judgment below, what generally happens? Right? In other words, the government lost in the lower court. Jacque filed an appeal. And the government's like, yeah, we're not going to defend this. What generally happens at that point? No. My question is more basic. You have an appeal, right? The government won below. And they say, you know what, never mind, we don't want to defend it. What happens to the judgment? Can the court affirm a judgment if the party doesn't actually want it? Both parties agree. Jacque says, I don't want this conviction. And the government says, we don't want this conviction. what usually would happen in that case? Yeah, you vacate the conviction. Right? Generally, if both parties agree that the judgment below is an error, you vacate the conviction. So what are we doing here? Why are we even here? My friends, welcome to New Jersey. You will find in your studies of law that the New Jersey Supreme Court is unique. They do the opposite of what judges usually do. Usually judges try to rule as narrowly as possible, having very specific rulings to address specific facts. Not in Jersey. This court for decades was known to go all over the place and reach rulings of great consequence in the most mundane cases. And here, where neither party wants to appeal, right? Both parties agree the conviction is invalid, they decided anyway. Basically, New Jersey appointed a lawyer to argue on behalf of a position that no one held. It's called appointing an amicus, or friend of the court. The U.S. Supreme Court does it as well. I'm not a fan, although I might be one of those one day. But the Jersey court basically made up a ruling where there was no dispute. All right. So first off, the court considers whether the trespass statute is unconstitutional. And don't worry too much about this claim. They don't go down this road. But the argument is that there's some constitutional limitation on the right to trespass, right? That there might be some reasons why you can't commit a trespass, right? It's unconstitutional. But don't worry about that. Instead, Corey, they talk about the right to exclude. And they say the right to exclude has limits, right? What are some of the limits the court identifies on the right to exclude?
Can't injure the rights of others.
Yeah, I think that's right. As a general matter, right, you can use your property so long as you don't injure others, right? That's like a phrase that's often repeated. And what I think the court finds here is that the way that Tedesco is using his property is quite literally resulting in injuries to the workers, the farmers, right? The migrant workers. So as a result, we can't have the trespass statute as a strict liability offense, right? That there's like basically an exception to the trespass statute if certain conditions are present, right? That is, if you're using the trespass statute as a means to harm others, then you cannot benefit from that trespass statute, right? If you're using the trespass statute to harm others, then you can't use a statute that way. And then the court says, property rights serve human values, and the well-being of people must remain the paramount concern of a system of laws. Now, Carson, let me ask this question. Let's compare the trespassers in the first case and the second case, right? Who was doing the trespass in the first case, Wisconsin case? Who was committing the trespass in the first case in Wisconsin?
The mobile home.
The mobile home companies, right? Were they very sympathetic? Why not?
Because, in contrast to this case in particular, people that were doing the trespassing were doing it for, a better overall reason.
A better reason? What do you mean a better reason? Tell me what the reason was.
To render aid, because this was a vulnerable class of people that they were trying to help.
So I think what you're saying, Carson, is that when you're assessing the trespass statute, the likability of the trespasser matters. Right? The thing the trespasser is trying to accomplish should matter when we're deciding whether there's a trespass or not. Is that what you're saying?
I don't know if it's that. I think it's more like your overall mission. I don't know if it's likability.
So, Mia, how do we do this, right? Is the difference that why does a trespass statute apply in the first case, not the second case? Why is it in one case, not the other? So if they're benevolent, if they're helping others, we excuse them. So is that, Elisa, is that in the trespass statute? Does the trespass statute, which is usually strict liability offense, you learned this, I think, clearly, say it's a trespass unless you're really trying to help others? So where does a court get this from? Common law. How can they make an exception to the law just like that? Is there a gray area in a strict liability tort? Isn't that like, you might not like negligence, but at least trespass is easy. There's no doubt.
I mean, I think they built in a gray area because it didn't fit out.
So you're saying that the people who developed the trespass statute did not have this sort of situation in mind? Yeah?
I would say public and private necessity allow you to trespass in some way.
Oh, I was going to mention that in a minute. Thanks for bringing it up. Allison, remember the public or private necessity doctrines from torts? Remember that? So when does that come up, right? When are you allowed to trespass in some cases?
For like urgent matters.
Okay, now was this ever codified by the statute, by legislature? Had these exceptions come around?
Just by happenings and events that like the situations came up.
Yeah. So do you remember in the Spelunking Explorers case, they talked about the murder statute, and they talked about the self-defense exception, right? There was never a time when they said, "Aha, let's legislate an exception to murder for self-defense." It's sort of evolved, and I think you make a fair point about the public necessity doctrine, right? It was never like legislated, but sort of developed. And I think what the court's doing here is they're making up another exception that the tort of trespass, the trespassing statute, cannot apply when the purpose is trying to help others, right? You're only trespassing for the greater good, maybe you'll say. Right? I think that's more or less the basis of the opinion. Because these people are good-willed, you can't enforce the trespass statute against them. Yeah, Giancarlo? Your family group. Did I tell you, I once invoked the public necessity doctrine. Ever tell you this one? It was snow. I mentioned this. So years ago when I was clerking in Western Pennsylvania, I was in the middle of a blizzard, and I got in my car, I was in a parking lot of a store, and I turned on my wipers, and they had frozen shut, so the wipers flew off, like they broke. And driving in the snow without wipers is very, very, very dangerous. So somehow I managed to this was awful. As I was driving, I had one hand out the window knocking, look, you do what you do. And I managed to get to the Walmart and I bought a pair of wipers, right? Try installing a pair of wipers in the snow. You can't, right? Even try installing wipers without snow. You have to snap these things on, right? It's actually not easy. And you can't wear gloves, and I was freezing. So I was really struggling. So I said, I made a decision, okay. There was a bank with a drive-through ATM. I didn't have to use the bank, but I pulled into the drive-through ATM. It was a cover. I was like, okay, and I installed the wiper. I said, okay, public necessity doctrine. And I actually said, yes, I'm trespassing. So I was actually thinking, I am trespassing now, but I need to install my wipers. Now, they didn't arrest me. No, nothing happened. I got home safely. But I think it's a fair point that sometimes you say the law didn't intend to extend to these sorts of bizarre circumstances, right? Could you imagine the bank manager calls the cops to arrest me because I was installing wipers on his drive-through ATM for 5 seconds in the middle of a blizzard? Probably not. But anyway, yeah, if there's ever a lot of snow, make sure your wipers aren't frozen. It's really bad when that happens, and they snapped right off. I like living here. I don't have to worry about that stuff. Who here has ever had to warm up a car in the morning? Do you know what that is? Right? That you need to go 30 minutes beforehand, turn the car and let it run in the driveway. That's just something you don't have to do here. It's just that doesn't exist. It's lovely. I don't have to worry about that anymore. Okay. I'm very happy here. All right. So at bottom, I think they carved out an exception to the trespass statute based on the mission of what these people were doing. Now, Haley, let me ask you the hard follow-up question. What precedent does it set, right? What other types of trespasses are now going to be allowed? For example, let's say I enter a private store and I start protesting and say that this store is abusing their workers and they're not being fair to the workers. I start picketing in the middle of their store. Is that okay?
I think with this precedent, they would argue that they're trying to benefit the greater good.
Yeah. So how far do we take this? Yeah.
I have a question because I read into the opinion, and is it just a disguise of trying to say that this is for government workers since it was a government?
I don't think it's so limited though. I know they made a big deal about the fact they were government workers, but I don't think the case is limited to those facts.
Because I was reading into that this applied to government workers. Because they say property rights are not absolute. It's not applied to government employees. Might be reading too much into it.
I don't read it that specific. I mean, they made a big fuss about the fact they were federal employees, but they weren't actually government employees. Let me make that point blunt. They were funded by the government, but these were nonprofits. So they weren't actually government employees, I don't think.
But I think it does have a difference between them that they're doing something for the government and is funded as somebody that just goes and protests out of their own.
Everyone gets government funding, my friend. If that's a limit, then it's actually pretty easy to satisfy that standard, right? The government funds lots of stuff, right? You all have student aid, right? You can student loans. You're all funded by the government, right? I'm not being pedantic, but I don't think that was part of the court's opinion. It was discussed, but I don't think it turns on it, right? But what the court does say is we will not apply the statute in this case. That there was no need to deny these people aid. That it would be unthinkable that the farmer can isolate migrants to the detriment of their well-being. So the court here is placing the well-being of the workers above any sort of inviolable, absolute property right to exclude.
You just said exactly what I was going to say, which was
Good.
like to me, it was like a weighing of rights, and their right to aid superseded the landowner's right to exclude.
It's a very clear opinion. I mean, that front, the court is very, I think, transparent what they're saying, right? Elias?
So, first point is, when exercising its exception, the court talks about how there was no alternative but to trespass. If there was an alternative, I guess it wouldn't be a necessity, right?
Say it again?
If there was an alternative to them trespassing, they could just stand at the property line and, tell them through a megaphone, come over here, please go north. Then it wouldn't be, if there was an alternative to trespass.
Oh, I see. So you're saying that there's no other reasonable way to get aid to these workers?
Yeah, they mentioned that it was the,
Mm.
it was like the only way they could do it was to trespass.
Yeah, and I think also if any of these farmers actually left, they'd all be fired. They'd lose their wages. So even if they had the megaphone and tell them to leave, they need to give them the treatment on the farm, and they couldn't have them leave.
Okay, so that's very important.
Right. At least with the Steenberg case, there was another route. They could have taken the rollers and drove on the road. Right. Here, I think what the court's saying is the only way to get this aid was by actually trespassing.
And in a way, if you were on behalf, if you were advocating for the farmer, they also mentioned later that the exception is valid, but as long as there's no hurt done to the
Yeah. I mean, what's the harm to the farmer by letting these guys on the property? Right. Is there actually any detriment to the farmer? I mean, maybe having an additional person on his farm. Maybe they're not working for a few minutes. I mean, you could go see them during their break, but there's no actual tangible harm. Yeah.
Where would immigration status come in? Wouldn't that be wouldn't he get in trouble?
For employing non-citizens. I mean, that's a federal matter. This is a state court, but
Maybe with that.
I think the court looks at that a different way. The fact these people aren't citizens means that they don't have the usual ability to call the cops because they might get in trouble. Yeah.
Yeah, my point was the detriment was to educate them.
Yeah.
That could be detrimental to the farmer.
Oh, I see what you're saying. If they learn about certain rights, that they may try to assert those rights. Also in the backdrop was unionization, and the farm workers union, Cesar Chavez, these other things, right? They're trying to unionize the farmers. This was also part of what was going on. And the farmer in that regard, I think Marissa's 100% correct, was trying to prevent them from even learning that unionization was possible for these workers.
Right after the point that Elias brought up, they said something that made no sense to me. Members of the press may not be denied reasonable access to workers who do not oppose the decision. It was only for that.
It was completely irrelevant to the opinion, right? Nothing was about reporters, and they kind of bury that nugget at the end. I think what they're saying is we don't want the farmers keeping reporters out because reporters make sure that we document what happens. It was completely irrelevant to the case.
So it's not justifying paparazzi trespassing, correct?
I don't think they have paparazzi in mind, but I guess it could extend there. Yeah. Look, this is the New Jersey court. They don't think through these things, right? That's not that I shouldn't say that, but that wasn't what they were getting at. They weren't thinking about paparazzi. They were thinking about the New York Times reporter for the to document these sort of abuses. All right. All right. So in short, in New Jersey, you have a right to exclude. but there's exceptions to the trespass statute when the well-being of others is at stake, right? You can't use the trespass statute as a way to prevent aid to these individuals. This issue comes up in the context of the First Amendment free speech, which you'll study at some point in your law school career. But I asked about protesters. There are a lot of cases about trying to exclude protesters from shopping malls, and then it turns on whether the shopping mall is open to the public, and there's these other sorts of issues. There's one fun case, if you're a card counter, right? If you can count cards, can a casino exclude you? And they routinely do. I was in Vegas yesterday. I hate Vegas. Terrible place, terrible place. When you fly to Vegas in the morning, just people going there are just awful. Like the guy next to me he ordered a scotch at 7 a.m. You're laughing. When you're ordering scotch at 7, you have a problem. It's bad. And the people going back from Vegas are just like, oh man, what? I was sitting down at a restaurant and the guy next to me put out his laptop. It was like personalloans.com, right? Just I hate Vegas. I was there for like 5 hours, get in and get out back here. But yeah, so can you exclude car counters, for example? There are a lot of cases about this. Okay. All right, any other questions? All right, let me summarize a bit, then I'll segue to our class for next week. The concept of the right to exclude sounds fairly simple in the abstract, but when you actually get down to the nitty-gritty, it gets complicated, right? Are you willing to put $100,000 worth of punitives for trespassing for about 5 minutes across a field? And if you think that's the good rule, do you then enforce the trespass statute in cases like this with farm workers to keep out these aid workers? Okay. Next class, we begin a new topic, what's called acquisition by find. Now, you may have heard finders keepers. That is kind of the rule, but not really. So just make sure you read the cases carefully. The first one, it's only a page long, but pay close attention to what's being said. Anything else? No? All right. Thank you all. I will be in my office if you need anything, and I'll see you all on Tuesday.